So previously I mentioned GIPS, and that's the Global Investment Performance Standards that were promulgated by the CFA. They are voluntary, but if you materially misstate them, then the consequences become voluntary, so to speak, along those lines. Basically, it's an industry standard to utilize for calculating and presenting investment performance results to prospective clients. There's a significant overlap between the Securities Act of 1933, the Exchange Act of 1934, and the Investment Advisors Act of 1940. So as we've already seen, there are rules and regulations that transcend from those various laws that affect cybersecurity and material misstatements along those lines. We've also seen a lot of other entities going after companies that make material misstatements about compliance on their websites and their security filings, etc. That was the case with the SEC, because the SEC examiners rely on the idea that the potential investor must not be misled. And what they found in this particular instance is that the individual who was not only fined was also stripped of his broker-dealer license for making a material misstatement. That is no different than making a material misstatement about HIPAA that we saw in the FTC's case. That's no different than making a material misstatement about cybersecurity like we saw in the St. Louis broker case. So there's a lot of instances where this is going to come about and where your potential liability lies. Now, the SEC recourse, they have two types of letters. You have a no action letter and then you have an action letter. The no action letter is along the lines of, you know, we've noticed this, you have an opportunity to correct it. The action letter is where you get into more serious trouble like we saw here. The advice from the SEC in relation to GIPS has to do with the ability of the firm to implement its intended strategy, and then your firm has discretionary authority or manages assets on a discretionary basis if it has the authority to decide which securities to purchase and see for a client. This is significant because, again, it expands one's potential liability if you are a broker-dealer, and misrepresenting any of the items associated with related cybersecurity standards can land you in hot water if that's the case.